Assalamualaikum and good morning to Madam Zahra and fellow friends. We are from Group 11. Today we will present about Chapter 13, Winding Up and Strike Off. Okay, our group members are Alif Hakim, Nurliana, Nurul Syafiqah, Nur Syahira, Raja Nur Farhana Qayyum and Syafiqah Hidayah. Okay, now we will start our presentation.
Okay, now I will start our presentation with a basic explanation of what is winding up. So winding up is the process of selling all the assets of a business, paying off creditors, distributing any remaining assets to the partners or shareholders, and then dissolving the business. So basically winding up is a process that we want to close our company. There are two methods for winding up: compulsory winding up by the court and voluntary winding up. For the compulsory winding up, it, uh, it begins with the presentation of a petition in court, meaning that we get an order from the court to close the company, while voluntary winding up is divided into two sections: members voluntary winding up and creditors voluntary winding up. For the explanation for these two will be explained by my group members on the next slide.
Seterusnya adalah voluntary winding up. Ground for voluntary winding up terdapat dua situasi di mana situasi pertama adalah tempoh yang ditetapkan oleh company tersebut telah tamat ataupun berlakunya event yang menyebabkan company tersebut kena winding up. Situasi yang kedua adalah resolved by special resolution. Particularly relating to resolution adalah maksudnya if the company pass a special resolution dan tak ada benda untuk menghalang dia, so the company tersebut tak boleh batal untuk liquidations. Seterusnya adalah member voluntary winding up. Member voluntary winding up is a declaration of solvency by directors has been made and delivered accordance to requirement of CA. Dalam member voluntary winding up ada declaration of solvency. Seterusnya adalah conversion to creditors voluntary winding up. Ini adalah sekiranya member voluntary winding up tu tak berjaya dan dianggap, maksudnya become insolvent, dan maka dianggap sebagai creditor voluntary winding up. Creditor voluntary winding up adalah company tersebut voluntary winding up dengan melantik liquidators untuk liquidate diorang punya asset tu. So ada beberapa situation yang perlu diorang buat, iaitu meeting of company, meeting of creditors, liquidation in creditors voluntary winding up, and property and proceedings.
Okay, now we move on to compulsory winding up. What is meant by compulsory winding up? Okay, company winding up their business by the court, which mean arahan daripada mahkamah. Okay, as shown on the slide, there is commencement of compulsory winding up. And isinya adalah winding up petition. There is 4 common petition, which is from contributories, creditors, judgments and liquidators. Okay, diorang ni akan memberi petition kepada kerajaan untuk mengarahkan sesebuah perniagaan ditutup. And then we have company's own resolution. Yang ni maksudnya bila sebuah company tu ditubuhkan dan dia ada resolution dia, and dekat resolution dia ada tulis sesebuah date yang di mana diorang memang akan tutup company itu di sekian-sekian tarikh. So diorang wajib tutup company pada tarikh tersebut. And then we have failure to file statutory report. Failure to file statutory report ni maksudnya company tu fail to declare diorang punya business. Okay, and then we have failure to commence business. Okay, yang tadi dia fail to declare, yang ni company tu dah declare but they fail to commence their business. Diorang gagal menjalankan bisnes diorang selama setahun ataupun diorang take a break selama setahun. So court boleh gulungkan company tu. And then there's a reduction of members, which means when the company dah tak ada members, that's mean diorang kena gulung tikar. And then they have an inability to pay debts, which means company tak boleh nak bayar hutang dan hutang yang terlalu banyak. So court boleh tutup diorang punya company. And then we have directors unjust or unfair, which is the behavior of the director itself. And lastly, we have investigation at minister's direction, which means yang ni dia berkaitan dengan agensi-agensi yang berkaitan dengan government. So minister akan mengarahkan court untuk membuat investigation terhadap beberapa syarikat yang gagal untuk membayar diorang punya hutang. So that's all from me for compulsory winding up. I will pass to next presenter.
So untuk duties and function of liquidators, liquidator ni ialah seseorang yang bertanggungjawab untuk carry out winding up of a company. Lepas tu untuk compulsory winding up, liquidator tu adalah wakil mahkamah, maksudnya dia officer kepada mahkamah. Untuk voluntary winding up, dia adalah officer kepada company tu, maksudnya dia adalah agent company. Untuk duties and functions, yang pertama for remuneration. Kat sini dia cakap untuk mahkamah akan tentukan jenis remuneration yang patut dibagi kepada liquidator tu. Lepas tu yang kedua, for the custody of company property, semasa proses winding up tu, semua property company adalah di bawah jagaan liquidator tu. For a statement of affairs, yang ketiga kat sini, statement of affairs ni dia adalah dokumen yang senaraikan semua aset dengan liability company tu. So dokumen ni dalam masa 14 hari hendaklah dihantar kepada official receiver from the date of winding up order. Lepas tu for the business to be carried on dengan authority court, liquidator tu boleh benarkan company tu untuk carry on business dia selama mana yang perlu, tapi untuk benefit winding up tu sahaja. Lepas tu yang kelima, for the appointment of special manager. Kat sini special manager ni liquidator boleh minta daripada court untuk special manager untuk inspect semua dokumen-dokumen yang berkaitan untuk winding up. Yang keenam, cost of winding up and insufficiency of asset. Kat sini semua cost, charge, belanja, termasuklah remuneration liquidator tu hendaklah dibayar utama. Dia adalah yang terutama, kena bayar dahulu. Lepas tu yang ketujuh, for the liquidator 6 monthly reports. Kat sini maksudnya setiap 6 bulan liquidator tu hendaklah buat report, and then buat report pasal winding up company tu. Lepas tu dalam masa 30 hari selepas dia dah stop jadi liquidator, hendaklah dihantar kepada registrar dengan official receiver tu. Lepas tu yang terakhir, for annual meeting of members and creditors. Ini dalam situasi kalau winding up tu berterusan selama setahun. So liquidator tu boleh summon meeting, sama ada members of the company atau meeting members of the company and meeting of creditors. Itu sahaja.
For the next part is power of liquidator. So first of all, we'll explain about the source of power. First, it is common law powers. And second is statutory powers. For common law powers, it is the liquidator may exercise the power as agent for the company, which the company is acting through him, and all common law principle of agency apply. Next is statutory powers. Statutory powers is divided by two: voluntary winding up and compulsory winding up. For the voluntary winding up, it is under section 456. It is exercised under Schedule 11 of Company Act 2016. While for the compulsory winding up, there have without authority of court, which is exercised under Part 1 Schedule 12, and with authority of court, which under exercise of Part 2 of Schedule 12. Move to the power of liquidator. Okay, first of all, it is for restraint on exercise of power. So the liquidators will exercise the power properly and recognized by the court as having both qualification and access to information. So by the power, the liquidator will make commercial decision in winding up. Next, for carrying on business. So for voluntary winding up, the company shall cease to carry on its business from commencement of winding up, except when they require liquidator opinion for beneficial winding up. For the next one is compulsory winding up. The liquidator has power to carry on business of company but with authorization of court. So the authority is not necessary during 180 days after date of winding up. Third one is making call on contribution. So for compulsory winding up, the court is empowered to make calls on all or any of the contributaries for payment of the company's debt and liabilities of the winding up. So this power may be delegated to the liquidator as an officer of the court, but the liquidator must not make any call without either special leave of the court or the sections of the committee of inspections. While for the voluntary winding up, the power for the liquidator to make calls may exercise the court's power of making call as prescribed in paragraph 4 of Schedule 11. Number 4, priority payment in full. Liquidator has power to pay any class of creditors in full, which is subject to Section 527 Company Act 2016. So the payment under this power can made over requirement to pay the preferential creditor. So for the voluntary winding up, there have two: creditor and member. For the creditor voluntary winding up, it is subject to approval of the court. While for the member voluntary winding up, it is free hand to pay debts proven because of company solvency. Next, number 5, compromising and making creditor arrangements. So for this, liquidator has power to compromising with creditors subject to the same requirement, the power to compromise debts. So for the unsecured creditors successfully applied for setting aside of an order to convene a creditors meeting to approve a scheme of arrangement. Next, compromising and recovering debt. Okay, for this, the court-appointed liquidator has the power to compromise debt due to the company without the court's authority as prescribed in paragraph B, part 1 of Schedule 12, which provided the debt does not exceed 10,000 ringgit. So for the debt that exceeds 10,000 ringgit, it is required for the authorization of courts. Next, number 6, compromising and recovering debt. Okay, a liquidator has power to do that without court's authority prescribed in paragraph 6, part 1 of Schedule 12, which the debt does not exceed 10,000 ringgit. But for the debt that exceeds 10,000 ringgit, they need authorization of court, which under part 2, Schedule 12, paragraph 1, 6, D and E. Okay, for the voluntary winding up, there have to members and creditors. For the members voluntary winding up, they need approval of a special resolutions, while for the creditors voluntary winding up, they need approval by court and committee of inspection under Schedule 12. Okay, the liquidator cannot delegate his power to compromise agent. And for both winding up, compulsory winding up and voluntary winding up, they has power to prove the bankruptcy of any contributory or debtor and to take out representation of estate of a deceased contributory of debtor. Next, bringing and defending legal proceedings. So, the liquidator has power to institute legal proceeding to assist in his functions of protecting the property given to defense. So for both compulsory winding up and voluntary winding up, the liquidator may bring or defend any legal proceeding in the names of company but without authority. In auctioneers selling company property. So, liquidator has power on both voluntary winding up and compulsory winding up, which is there has power to sell all or any part of the company's property, either it is immovable or movable. So, this power is prescribed in Para C of Part 1, Schedule 12. Okay, the liquidator may engage auctioneers, brokers, and other agents and remunerate them. Contract for sales, conveyance, and similar deed can be executed by the liquidator in the name of the company. Next, what is executing documents? Liquidator may do all acts and execute all deeds, receipt, and other documents in the company's name and on its behalf in both a winding up by the court and voluntary winding up. Necessary, he may also use the company's common seal. Number 10, drawing and accepting checks. So the liquidator may draw, accept, and endorse any bill of exchange or promissory note in the company's name and on its behalf. 11, borrowing on securities. So liquidator may obtain in credit on the security of the company's property. Power is subject to the rights of any secured creditors over the property. Next, liquidator may have power in convene a general meeting of creditors or contributories to ascertain the wishes of the creditors or contributories, and they also may has power to convene meetings if so directed by a resolution of the creditors or contributories or by a written request. In obtaining delivery of property. So as winding up by the court may order any contributory or officer of the company to pay, convey, or surrender or transfer the liquidator within such time as the court given, or maybe as fast as they can. While for the creditor voluntary winding up, the court may require the payment or transfer of any money in the hands of any contributory, receiver, officer of the company to the liquidator, such as money, property, or books. Liquidator has power to access the company's book and books kept by liquidator for the inspections. So any documents that are relevant to the affairs or subsequent to the company's winding up, it is taken to be prima facie evidence and need to be kept for 5 years from the date of the company's dissolutions. So, liquidator may destroy the books within 5-year period, but if you want to know, you may look at the page 499. Next, which is the very last, it is incidental powers. The liquidator has power to do any other thing which is necessary for winding up the affairs of the company and distributing the property. The liquidator is required to exercise in connection with the administrations of the particular company's affair, which it does not give more power than that. Okay. For the liquidator's right to recover in respect of certain sales to or by company, you may look in page 499, which is stipulated in section 530 of Company Act 2016. Thank you. I pass to the next presentation.
Effects of winding up. You can refer the book, page 500. I'll explain the implications of winding up. Commencement of a winding up triggers off several events. Based on the book, there are 6 in total, but I will explain briefly later. However, the main effect is that the company ceases from carrying on its business, except to the extent necessary, bila perlu. Effects ni ada 2. Firstly, effects of voluntary winding up, section 442, dan effects of winding up order ataupun compulsory winding up, section 475. Kalau baca buku memang banyak, tapi telah diringkaskan menjadi satu table, which is the comparison between compulsory winding up dengan voluntary winding up. Untuk implication aspek yang pertama adalah company business. The company business may be continued by the liquidator where necessary untuk beneficial purpose of winding up je. Ni untuk compulsory. Manakala voluntary, the company cease to carry business except in liquidator's opinion is required. Untuk yang kedua, director's power. Untuk compulsory, the board becomes functus officio ataupun hilang kuasa dan its power are assumed by liquidators. Manakala voluntary, all powers of directors cease kecuali dalam general meeting with liquidators' consent telah dibincangkan and approves the continuance of power. Yang ketiga, disposal of property. Untuk compulsory, any transfer or alienation of company's property selepas winding up order is void, terbatal unless court order otherwise. Voluntary, not stated. Yang keempat, contracts of employment. Untuk compulsory, winding up order act as a notice of dismissal of employees, Chapman's case. And voluntary pula, Chapman's case tadi tu does not apply rule dia. So, kalau liquidator tu wants to terminate the service of employees, he must make the positive move. Okay, yang kelima, legal process. Okay, under legal process ni ada 3. Firstly is commencement and continuation of process. Compulsory ni dia ada 2, before winding up dan after winding up order is made. Untuk before, company itself may apply to the court kalau diorang nak stay atau restrain further proceeding. Itu pun kalau ada proceeding yang pending. Kalau after winding up order has been made, no action ataupun proceeding may be proceed except with court's approval. Sama juga macam voluntary, no action ataupun proceeding may be proceeded kecuali with the leave of the court. Okay, yang kedua tadi, untuk execution restraint, compulsory dan voluntary, dua-dua kalau ada any attachment, sequestration, distress or execution put in force after the commencement of winding up is void, terbatal. Okay, kalau execution divide prior, it is dejected unless benda tu dicompletekan before commencement. Okay, yang ketiga, doctrine of lis pendens. Untuk compulsory, not stated, tapi untuk voluntary, dia bagi tahu yang constitutes ni a pending suit ataupun lis pendens in relation of company's property. Okay, untuk yang keenam, implication aspect adalah shares transfer. Untuk compulsory, transfers of share kalau made after the commencement is void unless court order otherwise. Kalau untuk voluntary, transfers of share tu after the passing of winding up is void unless transfer kepada liquidator tu sendiri dan berada dalam liquidator's consent. Okay. Lastly is right to inspect. Untuk compulsory, normally members ni ada authority ataupun right untuk inspect buku dan register. But since order to wind up ni, dia deny right tu, which is dia cuma boleh inspect with the court's order. Kalau voluntary, general rights ni are displaced and company asset tu termasuklah books and records are in the liquidator's custody. Thank you.
For settling debts and liabilities, It states here, in preparing his list of creditors, the liquidator is guided by the proofs of debt submitted by the creditors, which are received in accordance with a notice. Meaning that we have to settle our debts and liabilities before we can wind up our company. So there are 3 creditors that are shown here: secured creditors, preferential creditors, and unsecured creditors. Secured creditors is the one that lend us their asset for our business. For example, their property, which they own their mortgage, and we use it for the purpose of our business. For the rights and duties of the secret creditors, you guys can refer to section 524 of Companies Act 2016. Okay, moving on to preferential creditors. I will give you an example. The example is, let's say, an employer that his wages are not paid yet. So we have to settle that first before we move on to the unsecured creditors, which is this opposite of secured creditors, meaning they lend their money to us but not their asset. For their right and duties, you can see it at section 525 of Companies Act 2016.
Okay, next is distribution in compulsory winding up. It is a distribution of surplus among members. Okay, untuk compulsory winding up, the liquidator is not entitled to distribute without an order of the court, which mean diorang tak boleh suka-suka hati distribute diorang punya surplus. Okay, as shown on the slide, a liquidator of a company that is being wound up by the court shall settle a list of contributories if it appears to him it is likely that either, first, they are persons liable as members or past members to contribute to the company's property on the winding up, or second, there will be a surplus available for distribution. Maksudnya kat sini, kalau tak ada surplus available, maksudnya diorang tak distribute lah diorang punya surplus sebab memang tak ada surplus. Okay, and then it will be necessary to, 1, make calls on contributories, which means yang make calls ni adalah court, dan tujuannya adalah untuk to satisfy debt of the company or to satisfy cost charge of winding up process. And second one is adjust the right of the contributories among themselves. Maksudnya diorang adjust the distribution mengikut diorang punya hak masing-masing. So that's all from me. I will pass to next presenter.
Distribution in voluntary winding up. As we know, voluntary winding up is the decision made by the shareholders and the members to wind up their company. So all the assets and the proceeds should be distributed back to the shareholders. They should be distributed back to the shareholders based on their shares they hold on the company itself.
The registration of a company, strike off. You can refer to page 524. I'll explain the defunct company. When a company is defunct, it may be struck off or deregistered. Registrar akan hantar letter ataupun notice to the company if it has reasonable cause to believe that the company is not carrying on business or is not in operation. Seterusnya, power of registrar to strike off company, section 549. If company is not carrying out business ataupun not in business, the company contravene Companies Act 2016 ataupun company used for unlawful purpose dan lain-lain. Okay, seterusnya, notice of intention to strike off company, section 551. Before struck off, the registrar may serve on the company or the liquidators a notice stating that if an answer showing cause to the contrary is not received within 30 days from the date of notice, a notification to the public will be published. Seterusnya, objection to striking off, section 552. Nampaknya saya tertinggal dalam slide tu. Okay, when the notice is received, together with a prescribed fee, objection boleh dibuat jika company still carrying on business ataupun there is other reason to continue. Seterusnya, company tu adalah party to legal proceedings dan lain-lain. Seterusnya, boleh baca sendiri ya. Withdrawal of striking off, Section 553. Dekat sini bagi tahu, the application to strike off a company may be withdrawn by the applicants by lodging a notice of withdrawal with the registrar. Okay, seterusnya, the effect of striking off, Section 554. Kat sini, it states that the company is struck off from the register. The company shall be dissolved, but the liability of every director or officer company itu continues and may be enforced jika tidak di-dissolve. Dan seterusnya. Lepas tu ada reinstatement of the registered company. Under reinstatement ni ada power of court to reinstate a struck off company into register. Section 555. Seterusnya, management of assets of dissolved companies. Power of registrar to represent dissolved company in certain circumstances. Section 556. Dia ada bagi tahu yang jika company tu dah di-dissolve, registrar to find out that the company is legally or equitably bound to carry out some dealing, transaction or matter. So registrar tu akan represent the dissolved company to do or cause any such act to be done. Okay, seterusnya, outstanding assets of dissolved or struck off company to vest in registrar. This one is section 557. Boleh baca sendiri kot. Sorry. And then ada disposal of outstanding interest in property, section 558. Liability of registrar and government as to property vested in registrar, section 559. And lastly, accounts kept by registrar, section 560. Thank you. That is all from us, Group 11, regarding Chapter 13.